Okay, good morning, everyone. Welcome to our second roundtable presented by the Ethics and Practice Committee of the Dispute Resolution section. We are delighted that you all joined us today, and I just want to briefly name our committee members so you'll know those who are going to be talking. So we'll have Ken Carlson, Jackie Clare, Nicole Hatcher, Patricia Holland, Rick Igu, Tara Kozlowski, Frank Laney, and Ray Owens. We're missing John Bircher today, who had a court matter he had to attend to. Just a few ground rules as we are talking. The committee members may tell you a little bit about themselves as they begin to speak. We have over 120 folks registered. I don't know if all of those folks will show up. This is being recorded, and it will also be posted on, I believe, the section website. So if others who are not able to attend want to watch it, certainly they can click through. When we are talking, if you want to contribute to the discussion, if you will just limit your comments to just a couple of minutes at most, because we've got a lot to cover, and I think that would be helpful, and just kind of let me know that you want to speak. That our topic today is negotiations. And there, of course, is a lot that we can talk about with negotiations. Negotiation strategies are important for both the mediator and for the parties. So, Ray, I thought I would just start off with you. If you would talk a little bit about what you have seen in mediation as far as effective strategies go for participants, and then maybe we'll talk a little bit about how the mediator can guide that.
Good. Thank you, Ann. Obviously, that's the most delicate time, these early sessions, typically with the plaintiff. You want to be establishing relationships. You want to engage in active listening. You have someone you've never met before by definition. Sometimes the lawyers you don't know. So you have this clash of wanting to be friendly, for lack of a better word, with a need to shape expectations when you start to hear things. I guess my sense of it is, am I hearing unreasonable expectations from a party as opposed to a lawyer? It's more concerning to me if I hear lawyers talk about certain numbers than if I hear parties talk about certain numbers who are lay folks. But so I start to make distinctions then, and I typically don't. I want to keep the relationship as best I can. But if you hear, for example, I've got $250 in medical bills, and my brother, who's an IP lawyer in Berkeley, California, says my case is worth $1 million, you have to start shaping things. Well, California's different. Don't know your brother. Who knows? I typically would start to show a little bit of concern, active concern, but let's see. I've not met with the other side. If you hear things from lawyers, it's different. So there's kind of monetary expectations is what we typically hear, but you also hear non-monetary expectations. I want the hospital to change its protocol for the NICU, or I want an apology from the defendant for what happened. If it's non-monetary, I move pretty quickly to say, I can understand why you want that. But be careful, as you want non-monetary expectations, that your opponent may want to lower their financial offering to you. There's a time to talk about that. Let's talk about it later, but I understand where you're coming from. But if it, again, is coming from a lawyer, one exercise that I've done, and again, we all know as mediators and as lawyers in mediations, one size doesn't fit all, but I call this sonar. If I've had a written submission, we've had opening contentions, I'll hear the discussion, and toward the end, we'll be talking about numbers. I may say, I really don't believe you're going to get a 7-figure offer today, or a 6-figure offer, or wherever you want to draw the line, or I'm concerned about that. I didn't hear that. They're proud of their summary judgment motion, this, that, and the other. And the lawyer and I may have a discussion, and sometimes parties and lawyers will react, well, I'm leaving right now. And I said, I don't know whether they do or not, but I'm wondering if they're going to offer that to you today. Let's see. If you don't hear anything, I just kind of file it away. It doesn't mean that they don't have unreasonable expectations, but I note I've kind of pinged. That's why I call it sooner. I've pinged a certain range, and I haven't heard a response. And I love being wrong. I love later in the mediation. Wow, look at this. They are offering you seven figures, and that's a happy moment. Keep going. That's great. That's wonderful. But if you don't hear responses, it gives me a little bit of comfort, maybe notwithstanding the opening contention, this party and this lawyer are going to be reasonable. But if you have an unreasonable lawyer, you will have an unreasonable client. Typically, they've hired the lawyer. It's highly stressful. I'm going to follow his or her advice. Why would I want to care much about this overweight mediator and what he seems to think? He's from Charlotte. What do they know? So you have to work with the delicacy of in the early stages. But that would be one approach to take. Just maybe suggest some numbers and kind of see how people are responding.
Okay, so great, Ray. So let me just open this up to the group. I mean, it used to be, or at least in my experience, that people would just show up at mediation and see what happened. They didn't have a plan. They didn't know kind of how they were going to approach the mediation. Jackie, are you still seeing that? Is that something that has happened in your mediations? Do you see people coming in with a plan if somebody's too high or too low on the other side?
I mean, you do still see that, and I think a lot of that is just not being prepared. Too often we have that. I think the best mediations, are when folks do have plans. They don't react to the numbers on the other side. I mean, on the one hand, you do have to figure out what the numbers are on the other side because, plaintiff doesn't want to leave any money on the table, defendant doesn't want to pay too much. And so the numbers do, speak to, how things might end up. But on the other hand, folks will get bogged down and, I find myself just saying, look, you know what you want to pay, or what the value of your case is, work with that. I think that's the most important key, understanding the value of the case, for the parties. I do want to get to some of the things Ray said, follow up on that. And he did make this point, and I just want to highlight it, that when you do say, well, I don't think they're getting to six figures or whatever, you can't do that toward the beginning, because I mean, if you said, well, they're not going to pay 100,000, then that might just shut the case down. Whereas through the process, folks start to understand maybe my case isn't worth six figures. And Ray did say that that's later in the process, but you do have to be careful about doing that in the beginning, because folks just aren't ready psychologically to accept that maybe their case isn't worth that much. The other thing that I'll do when folks come in with their $25 million demands, for the $250 medicals, case, I agree with Ray, like, there's a sibling in California that, has a different value of the case. I will ask the lawyers, well, let's talk about Wake County. What have the verdicts been like there? What are the juries like there? I basically know the answer to that, but I want them, I'm not going to come in and say, well, this is going to happen in your case, because we're not supposed to. And, and I don't know what's going to happen, but just to kind of bring some reality to it, asking about the jurisdiction, like if you're at the mediating a case at the Industrial Commission, for example, there are statutes that control the value of the case and rules. And, if somebody says, well, I'm just going to ask the judge, the deputy commissioner for $1 million, I mean, you have to say, okay, let's talk about that. And so that, again, is talking about the value of the case. So anyway, I'll pass this. somebody.
So let's talk a little bit, Jackie. I think that's a great segue to how we as mediators can help guide the negotiations. Ken, what do you do when you have folks in the mediation and you kind of sense they're not being realistic? How do you help guide the negotiations?
Well, first of all, with patience, and I'd like to echo what Jackie said. Sometimes if we interject ourselves too firmly into what we think is the value of a case too early, it can really take you on to places where you don't want to go in the mediation. Yeah, I always remind myself and them that it's their mediation. I'm here to help them navigate. But if I start hearing, unrealistic expectations in the front, I really couple it with two things. First of all, I try to get them to be as reasonable as possible if they're here to really trying to resolve it. And both sides, I try to come out of the gate as reasonable as they can. But then I also volunteer this. I said, but I can handle anything you give me. You know, if you come out reasonable, we'll probably be able to close a gap, hopefully earlier rather than later. But, everybody has their strategies and I respect it. And that's the way I come out with it.
So, Trish, let me just ask you this question. I've had some cases where I've seen people do some interesting things in their negotiations. I had one defendant who offered maybe 75% of what he had available, and it was such a high number that it really helped the plaintiff get interested. Have you seen anything like that, or does that happen very often in mediations? I typically think people start too high and too low, but it's not my case, and so you just let them do that. But what have you seen that has been effective for litigators who are listening?
Way too often I see people start with a number that's way too high, and then the offer then is way too low, and I call it ping ponging. They go back and forth, and I always tell the plaintiff, I said, when I leave their room, I said, don't be surprised if you get an offer that you're going to consider offensive. It's going to be very low, but it's going to be reflective of what they think of your number. So don't be offended. That's just how it's going to go, probably for the first few rounds. I try to avoid that a little bit more and more by having pre-mediation calls with counsel, trying to sort of set the table a little bit. I find if I have time to do it, that is productive. And sometimes I can get the attorneys to avoid that huge gap in the beginning. So when I can find the time to do it, I do that more and more.
Okay, so Frank, how about you? Have you seen folks start in reasonable ranges, or are they usually in the extremes, and how do you deal with that?
More likely than not, it's in the extreme, and I think that they know it. Occasionally I'll get an attorney who really has no idea what the value is. Like one that stands out to me is there's a federal case, a federal statute that puts a cap of $300,000 on certain types of cases. And the plaintiff's opening offer was $500,000. And so to me, that indicated this person has no idea what their case is worth. They don't even know the statute that they're suing under.
Mm-hmm.
And so that's always a difficult person to work with. But like I say, my guess is they know that they're being extreme. I think it was Jackie was saying, no plaintiff wants to leave $1 on the table and no defendant wants to overpay by $1. So they start out at these fair positions, seeing if the other side will bite on, what I'm saying. So one of the things that I do, I've been told that I do, and put it that way, is patience. Sort of what Ken says is don't try to rush it. Be patient. The gold star at the end of the day for me is when one or even both attorneys, or all the attorneys, however many there are, say, I can't believe you got that case settled. I can't believe you hung in there with us. I had no confidence this case would settle, and I can't believe how long you spent with us. to get it settled. And, you know, I don't say it out loud, but my reaction is that's my job. You know, my job is to take the time, be patient. And so these are things that I don't think can really be hurried. They need to be managed completely. You know, I think our job, you know, sort of boils down to two things. On the active part of it is we are communication coach. We are helping them communicate better, and we're negotiation coach. We're helping them negotiate better. And I think negotiation coach frequently is the bigger of the two. Sometimes they really are bad communicators. We have to teach them how to communicate, but usually it's getting them to communicate better. I mean, to negotiate better. And even, you know, highly paid lawyers and big law firms, I've run into a few of them who are terrible negotiators. And so it's up to me to coach them along.
Yeah.
So like a little bit like junior high basketball, you know, just take it easy and, you know, just dribble the ball and you'll get your chance to shoot eventually. You know, we a little slowly and not try to rush things.
Yeah, let me add something to, if I could, to
Sure.
what Frank is saying and build on what everybody's talking about. There are kind of 3 points in just terms of how to manage it. One is I've got a couple of sayings that I frequently use that others probably use as well. One of which is, I don't care where we are at 11:30 in the morning. I care where we are at 3:30 or 4 o'clock in the afternoon. And that builds into the patience aspect. The other is to recognize that there are different negotiating strategies, and we really don't know what's being talked about in the private sessions when we step out. For all we know, they're saying what Frank and what Ray and what Jackie said is absolutely true. We're way overvalued. But you know what? We're going to stay high because we're going to try to anchor this in a certain way. And that leads to sort of that other statement of that I often give is amazing things can happen in the 59th minute of the 11th hour. We've all seen it, okay? We've all seen it where somebody has reached that point where they know they've basically done all they can to make sure they get the best resolution on the table. And then you see these amazing movements at the end. And then I think the last point is this. Sometimes, as we all know, the most difficult mediations are those where everybody comes out of the gate extremely reasonable. Because then everybody thinks that they've moved already. And so the hardest part is getting them to move in those cases where there's not a lot of movement left and everybody's kind of dug in. And that's sort of a different approach for that as well.
And so Ken, I think everybody is saying that patience is the real rule that you should follow as a mediator and as clients and attorneys. So, but let me just ask Rick. Rick, what kinds of cases do you do, and what have you seen as far as effective negotiating strategies?
Good morning. I'm doing fewer and fewer cases. I'm slowing down. I started teaching as an adjunct a few years ago. I'm doing more of that. I'm doing more arbitration these days. That being said, I get a fair amount of appointed cases out of Durham here. The clerks here know that I don't mind. In fact, I enjoy working with pro se cases. So I do a lot of those. So maybe I should hold back and see if we start talking about pro se cases, or should I open that up, Ann? I'm not sure.
Well, go ahead if you want to talk about. So how do you think negotiation strategies differ with a pro se party?
I find there's a bit more education without crossing the line into giving them legal advice. I try to prep them. I think Trish was saying earlier she has conferences early. I try to have conferences with pro se parties to be sure they understand what they're getting into, and have some idea about, coming in with a plan. As we've said, you do that with experienced negotiators as well, but I try to be sure they can do that. And then the patience aspect, I can't emphasize that more. My experience being a mediation coach in training and also an instructor, new mediators want to go really fast. And I think that can build with people who want to get a quick resolution. If the mediator's kind of feeding off of that too, I think that can shut everything down. So actually go slow, gather as much information as you can, and try to make them understand you're not in court trying to convince the judge or jury. You're trying to convince the other side. Now, if it's an attorney on the other side or a pro se party on the other side, you don't need to convince me. I'm the mediator. Those are the folks you need to address, and I'll help you do that as much as I can.
Okay, thanks, Rick. So Tara, you've heard this conversation, and we looked at Tara as kind of our our rules guide, and that sometimes we might say things like, well, I don't think you're going to get that number, or comments about where the numbers are. From the commission perspective, just give me your input on that.
So you all know that, mediators are not supposed to insert their will into the party's decision, right? Standard 5, I think, covers it very well as to what mediators can and cannot say. And the beautiful thing about our mediators is that you all have been trained to be crafty enough to ask the questions you need to ask that will lead people to where you want to lead them. And I hate to use the word manipulate, but at the same time, you have an overall view of everything that's happening. And if you think that going down path A is going to be more successful than going down path B, you can be creative enough to make comments and ask questions that will hopefully direct people to the proper path to find a resolution that everybody is equally happy, equally miserable with, right? To find that sweet spot to walk away with. And I think it's fascinating because Standard 5 is very much kind of the forgotten standard. It's fun to go back and read it, to really look at the language within it, to remind yourself of what you can and cannot say, what you can and cannot do. Oftentimes we hit on confidentiality and conflicts of interest, but self-determination is really huge. And it's a pretty big standard considering, how short the majority of our standards are. So it's not a bad idea to go back and just review that to make sure that you're in compliance when you're having these discussions.
So Tara, one of the questions I will frequently ask when I get a number that I think is just way out of line when the mediation has been progressing is, how do you think that number is going to be received in the other room?
Mm-hmm.
Or what is your expectation about what will happen once you put that number out there? Is there anything wrong with doing that?
No, I think it's brilliant. I think if you say to them, that's crazy, that's never going to fly, you're crossing the line. But when you're asking them their thoughts on it, well, how do you see this playing out? You're just asking questions. You're having them examine, what's going to happen in the other side, if it's going to make them so angry that they start yelling, or if they're going to be overjoyed with the offer. But it's when you insert your position on it, like, that's crazy, there's no way I'm taking that over there. Clearly you've stepped over about. And I've wanted to say that before, because it's, one of those situations where you're like, you got to be kidding. You can't expect me to go over there and actually say this without laughing as I'm saying it. But you have to be crafty as you do it.
I had one defense counsel one time tell me, when I asked that question, he responded, I don't care how they respond to it. I've given you a number and I want you to take it. And I'm thinking, well, gee, that's going to help the negotiations if you don't care how they respond to it. But things like that happen. So just maybe approach it with questioning versus a comment. And so have any of you folks on the panel ever had the defendant go first or encouraged the defendant to go first? And is there any problem with us encouraging the defendant to make the first step? I've tried that on a couple of occasions, and it's actually been successful given the right case, because I think the defendant can anchor the numbers by going first. If the plaintiff thinks they're afraid or they're going to come out with a huge number, if the defendant goes first, it might can help things. Just comments from the panel.
I don't do it. I don't encourage anybody necessarily to go first or not, but I certainly have had defendants who wanted to go first, and that's with me. And I think the reason is, as you mentioned, anchoring. I think that they realize that if they put a high 5-figure, very low 6-figure number on the table, that will anchor them outside that 7-figure range that they know that this case will never settle.
What about anybody else? Have you tried that? Yeah, Ray?
Yes, my experience is Frank's. I don't mind who goes first. I think we've all had the experience where somebody's made a pre-mediation demand, and obviously the plaintiff's expectation is the defendant is going to go next. What you don't want to get involved in, well, I'm not going first. Well, I'm not going first. You're supposed to go first. But I think in cases of significant exposure, sometimes if the defendant wants to anchor or set expectations, that can be a very good beginning and can kind of set the course for negotiations.
Have you folks had cases where the defendants will not tell their attorney what the authority is to settle the case? I've seen that more and more. I see, Jackie, you're shaking your head. So
Yeah.
talk about that a little bit.
I'm seeing that more and more. And I just, I wanted to say, why'd you hire an attorney? I mean, if you don't trust them to tell them, what you're willing to spend. I mean, the attorneys have experience. They know how to negotiate. They understand the case, the attorney on the other side. And I mean, it makes it difficult for the attorney to have a plan when they don't know what they have to spend. Now, the plaintiff side, I think often they're not quite sure. That can change during the course of the mediation. You certainly should have these conversations ahead of time if you're the plaintiff's attorney to understand, okay, here's our aspirational goal. This is what we're going to shoot for. And then this is our bottom line. But I'm seeing it a lot, when there's an insurance company involved and they will not tell their attorney what they have to spend. And I just think that messes with, the negotiation process. I mean, it really has changed over the years.
And is in your experience, is the person who is giving the number actually in the mediation, or are calls being made to the person who's giving the authority?
These are situations where calls are being made, for the most part, because when the adjuster's there, I think that they are having those conversations when I'm not in the room, about what they have to spend. And again, I do a lot of workers' comp cases, and the comp adjusters normally are not there. And that's, when the attorney has to make the call. But I think it really does affect the negotiation process.
So I have a good story for.
Yeah, Terry, you just cut off.
I did. I'm sorry.
That's all right.
I have a great family law story if I can jump in.
Sure.
This is back when I was representing a client, and we went into mediation with a very, very fabulous mediator. And I was representing husband, and husband had explained his entire situation. We had all the financials, we had everything that we needed to move forward. And the mediator could not get us to budge because we were, steadfast in our position. And the other side wanted an unbelievable amount of alimony. And I was just like, that's crazy. There's no way you're going to pay this. We're going to fight this. We'll go to court. We'll do this. We'll do that, whatever. And finally, the mediator, after about 3 hours of us just being steadfast in our position, pulled the attorneys out into a separate room. And the mediator looked at opposing counsel and said, you need to provide this information so we can move this mediation forward. And I'm standing there saying, what information? And the opposing counsel said, well, your client has been unfaithful throughout the marriage. And I said, no way. My client would never lie to me. And there's nothing to show anything that he's done anything wrong. And the opposing counsel pulls out a stack of paper. I'm not kidding. It was like 2 inches thick. And it is pictures, videos. It is everything that you do not want to ever have to see your clients do. And it was just horrifying. And I remember walking back into the room with my client and just, this is being recorded, so I have to kind of edit what I said. But I remember like just dropping it on the table and being like, are you kidding me? Like, you thought this would never come out? You put me in this position to make these arguments for you, and this is how you've been behaving? The case settled like 45 minutes later. It was done.
So that's a great story, Tara, because people tell us things in confidence as mediators. And they, of course, the minute they tell you in confidence and tell you not to tell the other side, you go in the other room says, oh, I mean to tell you this. And then the party thinks you've disclosed the confidential information. But how do you deal with someone who gives you information during the negotiation that they want you to keep confidential? but yet you know it will help get the case resolved. Have you had that happen? Anybody?
Yeah, and that's a great point, and I want to build on something else that Tara just inferred, and that is something I will frequently, if not always, say at some point during a mediation, that I'm a firm believer that mediation lives in a world of risk. And if everybody appreciates their risks, they find ways to compromise. But what they're compromising for is all the right reasons, because they acknowledge their risk. And Tara just gave a great example of risk reaching its climax with undisclosed information. But that kind of takes you to the next point, which is, yeah, I think we all hear information that we wish would be disclosed. I'm up front. I say, I wish you would disclose everything, but at the same time, because it'll increase the risk. And I try to poke and probe and try to find out what's confidential, what's not, what can I disclose? And it may be a pattern that gets elevated. You disclose X, see if it resonates. And if X resonates and affects the negotiation in a positive way for the client, you go to Y and you try that. But I think especially during active litigation and where there's still discovery and depositions to be conducted, we have to respect the strategies of the lawyers as well, because there are very well things that might not move the needle that are much better disclosed and used in the deposition rather than doing it in the mediation and giving everybody a heads up that we know that. So it's a progression. And I think, it helps to have been a litigator for 30 years, but I think we need to respect that.
Go ahead, Jackie.
You get that so often, the attorney will say, do not tell them this, and that's when I'll pull the attorneys together, because invariably that's the first thing the attorney says, exactly what they told me not to disclose. And it's the first thing they tell the other attorney. And so, that happens, 75% of the time. It's just crazy. The other thing is in encouraging folks to give information. If the numbers are just so far apart and the attorneys don't think that the case is going to settle, they're going to be less likely to get that information. Ken's point. But as it's moving along, and then if it kind of, you hit a roadblock, they might be more inclined, to give it. And I'm like really thinking about that mediation, trying to get it done. And then I've finally realized, it's not all about me. And, even though I'm trying hard, this case just really might not settle. And I've got to understand they might need that information, at a later time.
So, so Trish, do you use the same strategy like Jackie of bringing people, pulling out the attorneys with any regularity? How do you determine when that's appropriate?
Well, funny you should ask, because again, much like my pre-mediation phone calls, I am doing that more and more in mediations, pulling them into the kitchen, if you will, either physically or in Zoom into a third mediation room. And I have found it to be remarkably productive. And to Jackie's point, I'm amazed at how much more they're willing to share in those sessions than they are through me, because they kind of get wound up. And I don't know if it's that they all of a sudden trip and disclose something they didn't mean to, or if they intend to because they get kind of caught up in the moment. But yes, I've been doing that more and more.
One thing, but I would add, everybody has talked about these kind of attorney meetings, which I think is absolutely part of how do we change expectations? I think that's absolutely right. I will always ask the lawyer, I think it's a good time to meet with the other lawyer. Do you have a good working relationship with him or her? Mm-hmm. Because you could also lose ground with a direct meeting if they've been fussing at each other.
That's a good point.
Yes, but if they have a good working relationship, I would say let's get together, because I don't think the numbers are syncing up to me. And maybe you'll hear what Jackie said. There'll be a disclosure, or Tara. Thank God for social media. It makes mediation fun, right? Yeah, wow, I didn't know that, or this or that. And you can absolutely, and the mediator doesn't need to control every part of the process. That is, you can bring attorneys together, but I think you have to be very careful about parties being left unrepresented who believe now we have male lawyers, which is a wonderful thing, male lawyers, right? No, they're taking over my case. And you have to be very sensitive, I think, to gender, race, ethnic concerns. The same thing is happening to me. These lawyers are meeting separately and determining my outcome on something that's highly emotional for me. So you have to be careful you don't stay out of the room too long. Virtually is easier, as Trish said, but you have to be very mindful. You have parties sitting back in that room who are wondering what's going on. But I
And
do
how do you introduce that you're going to do that to the parties? I mean, I usually say something like, may I borrow your attorney for a few minutes?
that's exactly what I say, and I'll bring them back. We want to talk about some legal issues. It's kind of legal issues. I want to make sure that we're all in sync here. We're making progress, and I just want to talk to them. But I always make it my idea, so that it doesn't look like a lawyer is surrendering one or the other. I think it'd be a good idea for us to meet and talk directly, and they'll come back and report to you about what we've talked about, or I will come back and report and say, here's what we were talking about. Unless it's something as explosive as what Tara mentioned, then I'll say, this is your lawyer, your new lawyer. But I do think it's a good way to kind of jumpstart things if people are too slow in their expectations. But patience is the word. Frank is right.
And Tara,
And I think, well, sorry.
go ahead. No,
No,
I
Trish.
just want to ditto what Ray said. I am always extraordinarily careful when I do suggest that we have a breakout session to talk to the clients about why we're doing it and get their permission and their buy-in to do it, and that we will be back soon and we will tell them what we talked about. And I also use it, and this is sort of segues into another point on our list of points of discussion for today, when to introduce non-monetary terms to a negotiation, because I mediate mostly employment and or business court matters. And it's always tricky for me as to exactly when during the day to start introducing those non-monetary terms. And I call it the meta mediation because sometimes it takes as long as the actual monetary mediation takes. And so I find that sometimes pulling the attorneys out and starting the discussion on the non-monetary terms can be productive in moving things along.
And Tara, this discussion has reminded me of some either ethics complaint or opinion about, didn't someone, maybe a party, complain that the attorneys met and never involved them in the actual settlement? Am I remembering that correctly?
Yes, and I wish I had Maureen here today because she remembers it vividly. Apparently, there was a district that preferred to do mediations with the parties sitting in a different room, and the attorneys would meet with the mediator, settle the case, and be done. And it had so many violations littered through it, I can't even say it without the hair on the back of my neck standing up. But yeah.
So that's just something to be cautious of, even when we think we're involving the parties. They may not feel that they're being involved, or it may be as extreme as that situation that was in that district.
Well, and we also get a lot of calls from mediators who are not used to working with pro se parties, and they are concerned that they're not able to communicate directly with the party. And I have to remind them that they're a mediator, not an attorney, and that the party to the action is actually their client, and that the attorney is there to assist their client in the negotiations. So it's something that we constantly try to educate mediators that you are supposed to speak directly to the party themselves, not to the attorney. But there are a lot of mediators that will rely on the attorneys and only the attorneys, and it can be problematic, to say the least.
And
That's interesting. Yes, Frank.
I had a case, I'll say 10 years ago, with a couple of lions of the Wake County Bar, named people you would know if I mentioned their names. And it was a pretty significant, horrific case. The police fortunately shot this man only one time, but there was enough lead to tear up the housing unit that he was in. Fortunately, it all went over his head, but only one bullet actually hit him. Could have just, anyway. And so we mediated for, I don't know, 5-6 hours. And then one of the lawyers said, why don't mediator, why don't me and you and the guy across the table, let's go down the hall. And so we went down the hall, and I said almost nothing. The two of them talked directly to each other and basically said, look, if you can get 600, I'll try to get 600, and let's see if we can get this settled. And so they did, and they went and both got 600,000. And the case settled fairly quickly. And so I was driving home going, how did that take us 6? Why couldn't those guys have done that at 9:30 in the morning? And what I realized, and those guys obviously, or at least one of them obviously realized along the way, is the dance has value. Neither one of their clients settled that case for $600,000 at 9:30 in the morning. But the time spent examining the case, discussing the case, the ups and the downs, and seeing what flies and what does not fly, that dance has value, at least to the litigants, to the parties. The lawyers maybe have seen it so much that they came in knowing they would settle it for about 600,000, but it takes time to bring everybody along. And so, I learned there that, that patience patience is a virtue, and bringing the attorneys together is a very valuable tool. But I think it's a valuable tool, once again, toward the end, unless you have a real problem up front, unless you have, just something's really sticky, like, 2 inches worth of evidence that your client is sleeping around, that feel early later. But I think, once again, I think that those are very valuable tools, but sometimes they need to be used at the appropriate time.
So I have 2 other questions that I want to make sure we address. One is, when you are leading the negotiations, do you get numbers in the first time you meet with the client, or do you have a discussion? So that's one question I would like for us to talk about. And then the other is, when you have multiple parties, multiple plaintiffs represented by different counsel, or multiple defendants represented by different counsel, how do you decide with whom to start? So let's talk about the first one. I used to not get numbers in the first go round. I have changed to getting numbers in the first go round. What do you guys do?
Bob Beeson and I got into a physical fight, which I won, by the way, over this very issue. I'm teasing, we did not. He is a firm believer in discussion and stroking and loving care and kindness, and we're all going to get something done. And then the numbers start, and everybody is catatonic at the numbers. I think you have to start with numbers, and you still are going to be dealing, but don't try to muzzle it. Here's, they're starting at $10 million, but let's talk about what this means. I think you postpone a good process by having a lot of warm and fuzzy words, and then people still are upset and they still want $10 million, or I'm not going to offer you anything. Just go ahead, let's deal with the tough love early. And the process, as Frank said, just be patient. But he, to his grave, will deny that's the way to do it. And Bob Beeson is one of the best. So
anybody else?
I would agree with Ray that, generally speaking, I think the parties expect numbers coming out of the gate in some way, but that doesn't mean you don't have the discussion like you're talking about, Ann. You kind of have that, and then you have some kind of something firm to start with, whether it be numbers or whether it be some of the non-monetary things that sometimes are really important and need to be put on the table at the start. But I would say that, another thought on that is whether or not, the numbers themselves, that are being discussed would be so counterproductive that you're challenged to try to get past them at the start in order to make sure the mediation has a really firm foundation for beginning. And sometimes that takes, we keep coming back to the word patience, and then just sort of recognizing that every mediation is different. And so sometimes it takes more of that discussion on the background that makes the numbers make sense, because you may have to package it. And I will tell you that sometimes, the times when I don't think I start with numbers, or times, and it's fairly rare, where the parties have come there and nobody's really together on sort of what has happened and almost like the ground rules of the mediation itself. That has happened occasionally. I've in one area that I like Trish, I'm mostly employment law, business court. I do a lot of trade secret, non-compete mediations and things like that. And sometimes, especially in those non-compete, it's kind of like employment law's version of family law. It's kind of like a divorce in some way, and the emotions are really high. And people come to that because they have to. They'd like to get it resolved, but sometimes they are just in different places in terms of what we're even coming together to negotiate over. Because it's always more than the money. It's a lot more to the money with non-compete work. And so you have to get through that. Yeah.
And Keith, and I see you raised your hand. Did you want to comment?
Yeah, just kind of generally, I think there's obviously no right way, but probably the people are picking you because of your personality and because of how you approach mediation. So like, I feel like you have to go with whatever you normally do. I like to kind of charge in right away, because that's what people, I think, use me for when it's numbers driven or whatever the case may be. They come to me not because I'm going to hold their hands through the entire process. They either want me to help figure out their case from the beginning or kind of cut right to it. And I've found that there's value in saying things like, look, I'm here to help you settle the case. I'm not your therapist, but I want to care about what you're going to tell me. Also, how long we spend here depends on you, right? And so the faster we can get to where things are reasonable for you, and then see if I can match them up with the other side, the faster we're going to figure out whether I'm going to resolve this case for you or not. And sometimes like that direct type of conversation moves things way past, okay, well, let's stop asking for $4 million on a $500,000 estate, right? The craziness, my version of craziness, goes away because they realize that I'm just trying to cut to where they want to end up at the end of the day. So I found value in a very direct conversation, but that works for me. I think people come to me because of that reason. So to kind of circle it back to the very beginning, your personalities are probably why these attorneys have hired you to mediate their case. And so kind of channel the best things about you is how I look at it. And you utilize those skill sets, because it's not, you're not just picking a rando usually. Unless you're appointed, I guess. But if you're actually being selected, there's a reason for that.
And so that's a good point too. So let's go to Rick, because if you're appointed, and how do you have the warm and fuzzy discussions in both rooms before you take numbers, or what do you do?
I think both of those things are very important, and I want to hear all that stuff. So my tendency is to play off of where they're going. And if they want to do warm and fuzzy and talk and be emotional, I let them go on that. And then I try to direct them to the numbers, and then vice versa. If they're focused on numbers, I'll say, can you slow down a little bit? I'm new to this. It will be helpful for me, and I want to hear everything you want to say, and I want to know about the case. So can we talk some more about what happened and how I might not say how you're feeling about it, because pro se parties tend to let you know that up front. But so I kind of let them guide me, but I want to know about both of those things before I go in. Whether I share everything or not was going to depend on them, my judgment, and then giving me, permission to do so. But the more I know, and the more I feel prepared to understand and help them guide their negotiations.
We've got some great mediators listening. Steve, I don't mean to leave anybody out. Katawa's another, but Steve and John Harkavy, I'd be interested in their views about how you handle these expectations early. Do you start with numbers? Do you not start with numbers? I don't want to put
anybody else who's listening want to weigh in on that? And I can't see everybody for some reason, but jump in if you want to say something. If not,
I'm a big fan of tearing the Band-Aid off. I think a big part of what we do is ripping the Band-Aid off and giving people time to get used to numbers that they hadn't considered before. And so I'm more of the style of early and often encouraging the parties to break the news to each other about what's really going to happen, so that everyone has time to go through the stages of grief for the numbers that will never be. And they can be in denial for a while and still hope that the number that they want is going to exist. And then they can be angry, and then eventually they can come to a place of acceptance. But it takes time, and it's part of the process. And I think the sooner you start the process, the more likely that you're going to be able to get.
And so let me ask this question. So if, you know, you have people who tell you we're never going to get to six figures, and they say it to you over and over, but you really think they probably will get to six figures. How do you deal with that? Anybody, Steve?
I'll tell them, they say they're not going to get to six figures, but I think maybe they will. I mean, I'm telling them what they said, and I'm telling them what I think.
A little known fact is that all mediators from Charlotte have advanced degrees in psychology. I don't know. We're very, very adept in many areas. I think you hear them. I think you hear them out. Yes, I hear you on this, but look at this move, look at that move, keep talking to your lawyer. I always try to defer to your lawyer some, unless I think the lawyer's a problem, and then I don't actively say defer to the lawyer. We're making a lot of progress, but it's fascinating to me, the kind of tear the Band-Aid off versus the patience. And I think that's what makes mediators good and less good, because knowing case by case, you've got a widow, she doesn't need the bandage torn off in a wrongful death case. That's a very different, if it's an equity fund manager, sorry to offend anybody's family. Yeah, let's move quickly. You're being silly. This doesn't make sense. You're not consistent with your goals of getting this done and that done. But I don't know. I didn't mean to jump in. Somebody.
No, that's all right. Well, so let's try to talk about this issue, because I think this is also one that concerns me when I have, like, you have multiple defendants. Let's say you've got a corporation and individual defendants. Maybe they all have money in the game, or they don't, or plaintiffs represented by different counsel. How do you make a decision about the party to start with? Do you ask the parties? Do you just have a discussion and then decide which defendant's room to go in? I know it really depends on the case, but just some general thoughts about that. Frank, you may have had experience, especially in the Fourth Circuit, about that.
Usually I start with the party that brought the situation to the court that appointed me's attention. And I know that's an elliptical way of saying the plaintiff, because it's not always the plaintiff, but generally it's going to be the plaintiff. I start with that person. And so usually if I have multiple defendants, I will frequently, ask, and that's a question I'll ask the plaintiff or the plaintiff's lawyer, do you have a suggestion as to who I start with on the other side? Either who's the easy person to deal with, and therefore I need to start with them, or the tough nut I need to crack, and therefore I need to deal with them first. So I don't try to make suggestions. That's just what's going on in my head. But I will have that conversation with the one attorney that I'm talking with, which usually is the one on the other side if it's multiple defendants. Now, if it's multiple plaintiffs, sometimes what I'll try to do is to meet with them all together unless somebody objects. And then, I say, okay, so we may have a very quick conversation out in the hallway between me and some attorneys as to who's going to go first to talk to the mediator. But usually all the plaintiffs are at least willing to, maybe we're just going to talk about the case, not about the numbers in that particular conversation. But generally most plaintiffs are willing to talk together. So that's one of the tools that I will use, is to use the expertise of the people in the room, i.e. they have all dealt with each other. Who do you suggest?
Do you ever try to figure out who's going to be the easiest defendant to settle with, and try to get that settlement first? Have you thought about that? Anybody?
I would say that's a real tricky, because that's kind of divide and conquer approach. You got to be real careful with that. That usually comes out later in those multi-party mediations. At least it's been my experience. And to kind of build on what Frank said as well, though, usually you've got a good idea who's got the most skin in the game, so to speak. You've got a good idea as who's going to be the lead plaintiff, who's going to be the lead defendant. Usually that would be the guidance for me in terms of who I start with, but I try to get every different ideas about it. But every now and then you've got a situation where the lead party is maybe the most intransigent. And so it's best to sort of do an end run around them a bit, start with the others, try to get some consensus, especially with the defense, who are looking to the lead plaintiff to be the primary payor, so to speak. And if you can get some consensus there, it can really influence them. But it's going to be real situation specific. Yeah.
I usually do it from the standpoint of how the opening session goes. You know, let's say, for example, there are multiple defendants, and let's say this is, you know, a personal injury case or occupational disease case and a comp case. There's normally an attorney that's going to go first. You know, I'll say in the open, you know, who wants to go first or whatever. And normally it's, I guess, that defense attorney who thinks maybe they've, you know, got the most skin in the game. And then I, you know, let them take their turns as they choose. You know, often everybody, the ones who sit furthest away from me are the, you know, the ones that don't want to talk. But and then that way it kind of sets itself out. So it seems like it's objective in how I choose who I'm going to go see first. You know, I'll say, well, I'm going to go in the order of, you know, how we went and the opening, so that, you know, to Ken's point, you've got to be careful about the one that you choose as the one that's, you know, the most responsible, and try to follow it that way. And then as the day goes on, they don't know where you are or what you're going into.
So, and I have Bill Apple has a comment, and Keith, and I think you have a comment, and we have limited time. So Bill, jump in.
And that's okay, because I have limited knowledge, and that's a good coupling here. I just want to add, I guess probably my style in the 19 years I've been doing mediations has been categorized as what we've described this morning as a soft style. And I just wanted to point out that we all remember, we all know that while we're talking about when and whether to come up with the numbers and what to say and how to say it, I think that we all recognize that a big part of what we do professionally is to afford the parties an opportunity simply to be heard. They're going to either be heard by a judge or they're going to be heard by us. And I tend to have, I guess a predisposition to listen and let them emotionally, you know, get over that. And I just don't find that I'm able to make much headway as an intermediary if I don't give them the opportunity to have that hearing in the mediation room.
Okay, thank you, Bill. That's you know, as I think Keithan indicated, we all have our styles, and that I think is what we have to lean into, so to speak. So, but Keithan, did you want to add to this?
Yeah, briefly, to touch on Bill's point, I think direct and soft are not mutually exclusive, by the way. Like, you can be very direct, but still give process, right? But the point I was going to make is, and it's different in family law cases, but I'm currently more attuned to watching out about leaning on one party sometimes, because there's situations like domestic violence, like verbal abuse, just in inequity of power. And even when someone in that inequity is represented by an attorney, that type of person can be ground down in, like, kind of improperly by the end of the day. So more so when I see that I'm trying to keep my ears and eyes and feelings open to that situation. And when I see that, I try to lean on the attorney to say, do we need to take a break and come back another day? Y'all need to process? Do we need to make sure that everyone's feeling in a good, solid place where they can negotiate on equal footing? And sometimes, like when you say pick on the kind of easier defendant, I know you didn't mean it that way, but that just triggered me in my head. Like, sometimes they got to be careful about who I'm talking to and how I'm talking to them for that reason, because they're escaping a situation that has been almost entirely one-sided. Not everybody, but that does happen a lot in the family law context. So I know we're neutrals. That's not me giving away position or anything like that, but that's me trying to keep the process neutral for everyone, at least in my mind. So Tara can grieve against me for that one some other day. But.
Well, so that's an excellent point, and we have 1 minute left. So Tara, why don't I give you an opportunity if there's any observation you want to make from this discussion? I think your comment about the standards is very helpful. So let me just let you close.
I really don't have anything to add other than the fact that this was a fabulous discussion. And I love hearing that every single mediator has their own style, their own preference, their own way. The commission really encourages that you follow the rules and follow the standards. Past that, this is your case. It's your ability to get in, talk to the parties, listen to what they're saying. And we want you to act as case managers for that matter. So everything I've heard today has just been spectacular and I really appreciate it, except for Keithan, which I'll go after later.
Okay, well, thank you. And thanks to the fabulous panel. I really appreciate your participation and for everybody taking their time to attend this. We want to continue to have these. We will discuss what our next topic should be. Please let us know if you have ideas that you think we should address, and we will try to do this again in the next quarter. Thank you.
Thanks, everyone.
Thanks.
Thanks.